Hey everybody, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning and probate matters. Today we're going to talk about the all important question of do I need an estate plan? Before we get there, however, if you have any estate planning or probate questions, you can drop them for us or set up a free consultation at yourplanningattorney.com. That's yourplanningattorney.com. Now, the question of whether or not you need an estate plan first starts out with if you're over 18, the answer is yes, you do. Now, let's start before we get into the why you need one. What is an estate plan? First off, an estate plan is a written plan that protects you as a person, both for health and financial purposes, your loved ones for various ways emotionally and financially, and it also protects your assets to the maximum extent possible against things such as unnecessary tax liabilities, spend down for long term care concerns, or just the inappropriate or unwanted access to your funds from other parties. Now, back to whether or not you need one. And I will reiterate that if you're over 18, the answer is yes. And if you're 18 years old, 19 years old, your early 20s, what we start out with is your incapacity planning. Now, this is the part of the plan that protects you as a person. And that means that should you fall ill, get into an accident, or some other circumstance where you're unable to make your own decisions, you can designate the trusted people in your life to make those decisions for you. We also suggest not only having one person that you feel comfortable with, but also try to have 1 to 2 additional folks to step in if that first one is not available. And again, these decisions fall into 2 different categories: health and financial. Now, to give you a sense of reality and a real example, we had a father reach out about his 20-something-year-old professional daughter who was a single individual. She had fallen ill and was non-communicative at that time, and her recovery was really unknown. She had a job and an apartment in New York City, expenses, bank accounts, and other assets. And while the medical providers were able to take direction from the father as a next of kin for health purposes, there's a possibility that sh- that he would have had to go through what's called a guardianship process to be designated to take care of the things long term. And if she had chosen someone, under her estate plan, that would have been avoided. If her condition worsened, of course, circumstances such as living on machines or a ventilator, life support that sustained her in that state where they said there's no chance of recovery, a living will would have been further help to them. And designating her as, again, designating the father or some other choice person, maybe her dad wasn't her first choice, on a health care proxy or power of attorney, depending on where you live, would have been useful so that the doctor, the medical providers at the hospital would have known exactly what her wishes were and whom they should be speaking with. And of course, without further authority on the financial side through a power of attorney, her dad couldn't access any of her things and maintain her normal course of financial life, especially since most of her stuff was electronic, as many of us have things coming via email instead of mail. Now, if her health had continued in that same direction without improvement, the family again would have had to go through a guardianship proceeding. And that could be not only involving a court, but it could cost them 20 times as much as it would have been for her to set up the documentation, proper documentation. Would have created a lot more emotional stress for them going through that process and would have taken quite a bit of time. Luckily, in this circumstance, the daughter began to recover and she was able to help them transition a lot of her life changes that needed to occur at that time. Now, that's not always the case. And a far more famous case that you could look up if you've never heard of it is 𝗘𝗀𝗁𝗍, which occurred in the early 90s down in the state of Florida. And if you want the spelling, it's 𝗘𝗀𝗁𝗍. This resulted, unfortunately, in a very expensive 7-year legal battle between the parents and the husband over the removal of life support that could have been resolved with a couple of healthcare directives that are easy to put in place and cost nominal amount comparatively. Now, in addition to protecting yourself, many folks who prepare an estate plan do so because they love their family. Now, by taking the time to think through your wishes and to put things in writing, you've helped them with who will be in charge later. Now, maybe you don't care to make it easier on them, especially because you won't be there, but it does make it easier for them if you have your wishes known, written, and a professional involved that can help them through that process as well. And if you want to make it easier for your family, it helps to have that plan set. Now, without a plan, state law where you live will actually control everything. And the first individual, maybe not necessarily the best individual of the family members, may be the one who ends up in charge. Now, that may be okay in your eyes, but it could also be a scary thing. Now, the division of your assets could be very different than what you expect. For example, within the last year, locally, a young father passed as the owner of a home and some other accounts. And without a proper will or trust in place, the default beneficiaries of that home, which was solely owned by him, it wasn't just his wife. It actually went not partially to her, but also to 3 minor children. 3 minor kids were part owners of their home. And they will get access to that interest at the age of 18. Now, that's a little strange, I think, and a lot scary. So it's possible to build in additional protections for your beneficiaries that wouldn't otherwise be available unless it's put into writing. Now, most relevant in my eyes, and something we do 99% of the time, is we create creditor insulation for all beneficiaries. And this is really hard to come by with our own assets unless we give something up. Okay. But that's not necessary here. We can give your beneficiaries lifetime creditor protection and allow them to be the managers of those assets. That's pretty cool. Now, this is a type of protection that you cannot add later, but it can always be peeled away if it makes sense. So it has to be created under your plan now, as it will not be allowed later. Now, all of this was a discussion about whether or not you should have an estate plan before we've even mentioned assets. And many folks believe that they do not need an estate plan unless they have a lot of assets. People say millions of dollars, etc. Now, I hoped we've debunked that notion today. Of course, if you do have assets that you want to ensure are provided to your loved ones in a specific method and with the most protection possible, then you need it in writing. If you prefer to have the right people to manage those assets and take care of your final expenses and follow through properly with your wishes, then it needs to be in writing. And should you want to minimize tax consequences, avoid your hard-earned assets from being spent down for care costs, and have your own creditor protection possibly, those wishes need to be thought through with a qualified counsel and put into writing. So I hope you see that there are various reasons to set up an estate plan, that if you're over the age of 18, you should absolutely have an estate plan. And there are various ways to protect yourself, your loved ones, and your assets through doing so. As a reminder, if you have any estate planning and probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. I thank you so much for listening, and if you found this information useful, please share, like, and subscribe where appropriate so you and others don't miss out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning and probate matters. Be well and take care.